Dear participants of the briefing, we are glad to present our expertise on systemic problems with the freedom of assembly in Russia in the context of implementation of the European Court of Human Rights judgment, Lashmankin and others versus Russia. My name is Denis Shedov. I am a lawyer at the Russian human rights media project OVD-Info. My colleague Tatiana Chernikova is a lawyer at the Human Rights Center Memorial. Our organizations are focused on freedom of assembly in Russia. Human Rights Center Memorial is one of Russia's oldest human rights organization, which has a significant litigation experience in the European Court of Human Rights. OVD-Info monitors freedom of assembly violence in Russia for almost 10 years. This year and the last year, we sent a submission under Rule 9.2 on implementation of the general measures in the case of Lashmankin. The key case concerning issues of restrictive authorization procedure for public events, legislative bans on holding public events at specific locations, mass detention and arrest of peaceful demonstrators, excessive security measures taken by the police during public events in Russia, etc. The Committee of Ministers has examined the implementation of the Lashmankin case twice. After the September session in 2020, the Committee of Ministers decided to resume an examination of this case in June 2021. At the last decision, the Committee of Ministers noted certain positive steps of the Russian government. At the same time, the Committee of Ministers strongly urged authorities to continue legislative reform to improve domestic court practice in the sphere of freedom of assembly, to exclude criminal sanctions for peaceful protesters, to provide information and statistics about the authorization of public events in Russia, to send message of tolerance of peaceful assembly. That means stopping the practice of mass arrest and persecution of peaceful protesters. In the recent action plan, the Russian government informed the Committee of Ministers about the steps taken to implement the Lashmankin case. Many of them were about the dissemination of the European Court of Human Rights findings in this case. Some legislation changes were also mentioned, particularly the Code of Administrative Court Procedure enacted in 2015. As a positive step in freedom of assembly, the recent amendments in the Public Event Act were considered by Russian authorities. In practice, these amendments significantly restricted assemblies and solo pickets, complicated the work of journalists during protest, made it possible to bring the participants of peaceful assemblies to new criminal charges, and applied social networks to block information about unauthorized demonstrations. There were also mentioned the Russian Constitutional Court's judgments, which prohibited bans for holding public events in some specific locations, and the followed reform of the regional legislation. Lastly, the positive Supreme Court's resolutions and overviews were also mentioned by the Russian government. What what does it mean in practice? My colleague Tatiana Chernikova will tell more.
Thank you, Denis. The situation in practice is very different from what is described in the government action plan. We see that spontaneous assemblies are still not authorized in Russian law, even if they are peaceful, include few participants, and create no disruption to the ordinary life. Procedure of approval of assemblies become more strict. The organizers are obliged to agree with the alternative places proposed by the authorities. Some new restrictions to the Russian law on assemblies were adopted. For example, the prohibition of international and anonymous fundings of assemblies, new obligation to the journalist, the obligation to the social network to block the information about the non-authorized assemblies. There is still a legal possibility to detain individuals for the participation in non-approved assemblies. The administrative fines are very high, and the administrative arrest still exists for the participation in non-approved assemblies. There is still a criminal liability for the multiple participation in non-approved assemblies, and it was applied in practice during the last year, for example, in the case of Yulia Galyamina. More than 13 individuals were detained during the last year during the participation in the mass assemblies. Many individuals were detained before and after the assemblies and faced different punishments related to the participation in public assemblies, and also they faced police violence and hard condition of detention. We will now show these main numbers related to participation in freedom of assembly. So the number of the detained protesters, at least 126 protesters were subjected to criminal prosecution, and at the opposite, criminal case against the policemen who use the violence during mass assemblies are not opened. There are important shortcomings in the government actions related to the freedom of assembly. There are no proposals for legal reforms necessary for implementation of Lashmankin case, no proposal for authorization of spontaneous assemblies, for liberalization of procedure of approval of assemblies, no proposal for abolition of criminal liability for multiple participation in non-approved assemblies, etc. There are also no valuable explanation for new legal restriction adopted in Russian law during the last year. And there are no valuable explanation for mass detention of protesters in practice in Russia during the last year and for prosecution of these participants. We have also prepared some concrete proposals related to the implementation of the Lashmankin judgments. We propose to legally authorize the spontaneous assemblies in Russia, to liberalize the procedure of approvals of assemblies. For instance, the organizers should freely choose the place and time of the assembly. We propose to abolish the criminal liability for multiple participation in non-authorized assemblies, to abolish the administrative arrests for participation in non-authorized assemblies, and to reduce administrative fines. We also suggest that the authorities regularly provide to the Committee of Ministers the information about the number of assemblies which were authorized and non-authorized in Russia, in order that the Committee of Ministers can monitor how tolerant the Russian authorities are to the peaceful assemblies. Our general conclusion is that the Lashmankin judgment is currently not implemented, and at the opposite, the authorities show a message of intolerance for public assemblies, both in law and in practice. We thank you for your attention, and we will be happy to reply to your questions.